for the Judiciary Decentralized Office, or JDO, in the 7th Judicial Region.
Yes, Your Honor.
But as I read, the Chief Justice refers to two administrative orders issued by the Supreme Court. One dated November of 2006, and in fact, if I may read, in the very first paragraph, the Chief Justice in this administrative order states, pursuant to the unbanked resolution of the court in AM number 06-11-09 SC, dated 14 November 2006, entitled, open quote, implementing the pilot project on enhancing the autonomy, accountability, and efficiency of the judiciary and the administration of justice, establishing and operationalizing the pilot organization infrastructure, providing for general implementation arrangements and other purposes. So this, in fact, refers to a previous resolution already passed and banked way back in 2006. Is that correct,
Yes,
Justice?
Your Honor. Yes, Your Honor.
And this resolution, if we were to read this in full, this particular resolution, in fact, authorizes the operationalization of the pilot decentralized project, in particular, the establishment of the pilot ARCAO in the 7th Judicial Region. That would be a more complete representation of that particular resolution. Is that correct, Madam Justice? My question is, first of all, can a Chief Justice create an office?
No, is one of my objections.
But yet the title of this administrative order refers to JDO, not ARCAO.
Yes, Your Honor, and it is permanent in nature. It's not an ad hoc body.
So a Chief Justice cannot create an office?
No, she cannot.
Neither can, as already established by the majority leader in his interpellation, neither can the judiciary. Is that right?
Yes, Your Honor, unless, as the Vice Chair of this committee mentioned earlier, there must be a valid delegation from the legislative body for,
Therefore,
for an executive official or any official of the judiciary to be able to create an office.
In fact, in your December 3 memorandum, you did make mention, paragraph 2, of, and you state, the AO of the Chief Justice cannot deprive the court and bank of its constitutional duty to exercise administrative supervision over all courts and their personnel, and the Office of the Court Administrator of its statutory duty under Presidential Decree number 828, as amended, to assist the Supreme Court in the exercise of said power of administrative supervision. In other words, it was by Presidential Decree 828.
Law during the time of President Marcos.
That is right. And yet, strangely enough, in this administrative order, as the Chief Justice designates the head for the Judiciary Decentralized Office, or JDO, her reference is, I'm just quoting directly from this AO, pursuant to the unbanked resolution of the court in AM number 06-11-09, dated November 14, 2006, implementing the pilot project on enhancing the autonomy, accountability, efficiency. I've read all of this. Is this referring to the ARCAO?
She is referring to the ARCAO because she has to find a legal basis. Or
But I do not read nowhere in the administrative order is reference to the ARCAO made conveniently.
Yes.
And yet, in her verified answer, denying the allegations set forth by Attorney Gadon, and may I ask my colleagues, if you would wish, you have your verified answer copy, page 25. She states, on November 14, 2006, the Supreme Court and Bank approved AM number 0611-09SC, which, among others, authorized the operationalization of the pilot decentralized project. In particular, the establishment of the pilot ARCAO in the 7th Judicial Region. There seems to be an omission in the administrative order, and yet, in the defense, in the verified answer submitted by the Chief Justice, ARCAO is now prominently referred to, which is in fact the essence of AM number 06-11-09-SC. Is that right?
Yes, precisely, Your Honor. That I mentioned that nowhere here is the Office of the Court Administrator or the ARCAO mentioned.
I just found it striking, Madam Justice, that I have just mentioned one Supreme Court and Bank resolution, because in the second paragraph, this administrative order signed by C.J. Sereno further states the role, authority, and responsibility of the JDO head shall be in accordance with the unbanked resolution in AM number 06-12-06-SC dated 18 March 2008 as amended on 11 November 2008. And if I would read the verified answer of the Chief Justice, page 26, paragraph 42, on 18 March 2008, the Supreme Court issued a resolution in AM number 06-12-06-SC, which established the detailed operationalization mechanisms of the pilot ARCAO-7 and defined the authority of the designated RCA and the DRCA. Now, what befuddles me, in this administrative order, I guess we have pretty well established that the Chief Justice cannot just create an office. She cannot create an office.
Yes, Your Honor.
And that this JDO, if this were to refer to another office, would be inexistent, because this administrative order would be null and void because she is not vested with the authority to create a new office.
Yes, a permanent office.
Yes, to create a permanent office.
But,
yes.
If it is an ad hoc office, then perhaps that can be justified. But she
Yes.
said it's like the provision seems to be making the JDO permanent.
And yet, strangely enough, all unbanked resolutions, I see here too, referred to by this administrative order in order to give strength and justification for the creation of the JDO, and further giving powers and responsibilities and functions to the JDO head. And I refer to AM number 06-11-09-SC and AM number 06-12-06-SC are specifically referring to ARCAO.
Your Honor, if I may give you an example
Yes, please.
of what the previous Chief Justice has done. I'm referring to Chief Justice Renato Puno. He wanted to revive the ARCAO, and he issued an administrative order number 16-2008, and he designated the personnel of the Regional Court Administration Office based on the same resolutions mentioned by the Chief Justice Sereno in her administrative order. And what Chief Justice Renato Puno did was to designate the Regional Court Administrator, the Deputy Regional Court Administrator, the Assistant Regional Court Administrator for Budgeting, the Assistant Regional Court Administrator for Financial Accounting and Disbursement, the Assistant Regional Court Administrator for General Services, the Assistant Regional Court Administrator for Human Resource Development, and the Assistant Regional Court Administrator for Revenue Management. This is a genuine implementation of the two resolutions to which the Chief Justice only gave lip service.
May I know, would it be...
Kindly submit that record to the committee, Madam Justice.
Yes, Your
Madam
Yes, Your
Justice, would it be incumbent and in fact expected of the present Chief Justice to be aware of that particular memorandum?
Perhaps she's aware. I do not have the.
Is it a
I
responsibility
have no personal knowledge
of the Chief
about that.
Justice?
But the thing is, I think there is.
Would it be incumbent?
Yes.
When
yes.
you take over an office, would it be incumbent upon you to be aware of previously issued and approved resolutions and memoranda?
Your Honor, I think there is a deliberate desire to remove this JDO within the organizational machinery or setup of the Office of the Court Administrator. So she really didn't want to use the term arcaw. She didn't want to use the term regional court administrator or deputy or assistant regional court administrator. I think it is deliberate on her part not to use these titles.
Is that proven by Administrative Order 175-2012, which never mentions ARCAO and yet refers to and bank resolutions which specifically created the ARCAO and operationalized the processes by which the ARCAO would function?
Yes, Your Honor. And the fact that she cited these two court resolutions about the ARCAO gave rise to this confusion. What is this body really?
Because it has been well established that she cannot create a separate office or a new office of permanent nature.
Yes, Your Honor.
And therefore, we cannot say that a JDO is in fact a different creation and another office.
Yes, Your Honor. That will be the effect of her citing the two resolutions of the court on the
Just to put emphasis, those two resolutions which specifically refer to ARCAO. No further questions, Mr. Chair.
Thank you. We now recognize Vice Chairman Ching Veloso as our last clarificatory questionnaire
Thank you, Mr. Chair.
on this issue. Yes.
Your Honor, I still will call you Your Honor. I am referring to your letter dated December 3, 2012. And it reads, paragraph, I regret that I have to write this memorandum in connection with resolution in AM number 12-11-9-SC, supposedly adopted by the court and bank on November 27, 2012, a copy of which I received this morning. With due respect to the Chief Justice, to my recollection, the resolution does not reflect the court's deliberation and the consensus of the justices. Your Honor, when you say it does not reflect the consensus of the justices in bank, my first clarificatory question is, one, this letter was triggered by the November 9, 2012 Administrative Order 175-212. Is that correct?
Honor.
So this was what you received, which resulted in your coming up with this memorandum dated December 3, 2012.
Yes, Your Honor.
When you say it does not reflect what the court and bank agreed upon on November 27, 2012, I will just focus on JDO, the Judiciary Decentralized Office. Because if I am to understand from your letter, in your recollection, the court and bank never agreed to put up a judiciary decentralized office when
Yes.
it met on November 27, 2012.
Yes, Your Honor. Perhaps the first time that they learned about the JDO is when I wrote this letter, this memorandum.
So, in a nutshell, what Administrative Order number 175-212 does is it attributes to you as a member of the Supreme Court who participated in the deliberation of the Court and Bank on November 27, 2012, a matter that actually did not take place.
Yes, Your
Relative to JDO.
I would say that it was contrary to what we decided on.
Very good. The reason why I'm asking that is that, Your Honor, Article 11, Section 1, Accountability of Public Officers. It is mandated that a public officer should act not only with integrity, but with justice. These things that you have recounted would tell us that the Chief Justice has been unjust in coming up with this Administrative Order number 175-212. Is that correct? In relation only to Section 1, Article 11.
To be truthful is to be just.
Okay, that's good. Now, because if you are not being truthful, Article 171 of the Revised Penal Code provides the penalty of prisión mayor and a fine not to exceed 5,000 pesos shall be imposed upon any public officer, employee, or notary who, taking advantage of his official position, shall falsify a document by committing any of the following acts. Number 3, attributing to persons who have participated in an act or proceeding statements other than those in fact made by them. The conclusion this representation has is this administrative order attributes 175-212. This attributes to you, a member of the Court and Bank, who participated in the deliberation of November 27, 2012, something that is actually different from what you agreed upon.
Honor, may I decline to give my conclusion?
Okay, that's just like yesterday. According to the Secretary of Justice, it is for the members of this committee to make conclusions, not for the witnesses. Thank you for again acknowledging that it is for us to make the conclusion, but I just read to you Article 171, Paragraph 3, as well as Section 1, Article 11 of the Constitution, to drive home the point, one, because this was made subject of an earlier interpellation, there has been a violation of the Constitution, Article 11, Section 1, by the respondent Sereno, and number 2, it is culpable in the sense that she violated Article 171, Paragraph 3 of the Revised Penal Code. That would be all.
Thank you. Thank you for that, Vice Chair Veloso. One last point on this.
Mr. Chair, much has been said of the memo of Justice Leonardo de Castro dated December 3, 2012. But as I recall her testimony or what she shared earlier, there is a previous memo which she wrote and which I actually asked a copy for. I believe we asked that this be entered into the records, and I believe this is a copy of the memo. We borrowed it from you, Madam, consisting of 1, 2, 3, 4, 5, 6, 7 pages. Could the page show this to, just because there's only one copy, we have not been able to reproduce it. This is actually from your papers, ma'am, but I will show it to you nevertheless before I take it up for comparison.
The committee takes note of this first letter provided us by the resource person, Madam Justice De Castro. Let this be entered into the records as well.
This is a very short point, Mr. Chair, but I believe it is valid to our discussion, and I move that the committee take cognizance of the letter and copies be furnished to all those interested. But the first paragraph itself, and may I read, this refers to the it is hard to read because I believe Justice Leonardo De Castro had it received, no, by all the offices of her fellow justices. So you can see the receiving copies all on the front. And it says, this refers to the aforesaid invitation extended by the Chief Justice, the Associate Justices, to attend the reopening of the RCAO in Region 7, which was not deliberated upon nor approved by the court and bank. So it speaks for itself.
Yes.
Mr. Chairman. No further questions, Mr. Chairman, and we will study and reserve the right to make questions based on the document upon further study. Thank you, Mr. Chairman.
Thank you. So, thank you for that. So now we will go to our next charge, which is falsification by the Chief Justice of the draft TRO of the Supreme Court in GR numbers 206-844-45, 206-844-245. Is that how it should be? Senior Citizen Party List case. So we now recognize the Honorable Majority Leader to introduce the pertinent allegations in the complaint to establish the charges.
Thank you, Mr. Chairman. Good afternoon again, Madam Justice. One of the allegations contained in the verified complaint is, as stated by the Chair, in regard to the case of the Coalition of Associations of Senior Citizens. It states here, ma'am, that the case was assigned or raffled to you, to your honor, and that immediately upon review of the petition, Justice De Castro recommended the issuance of a temporary restraining order and sent a draft of the order to the office of Respondent Sereno. The next paragraph alleges, ma'am, that Respondent Sereno, however, deliberately tampered with and altered the contents of the draft temporary restraining order sent by Justice De Castro by issuing a, open quotation marks, blanket TRO stopping the COMELEC from making further proclamations, thus benefiting other groups that were not party to the case, close quotation marks. Then it states in the next paragraph, it was only after, open quotation marks, obviously the complainant was copying this from newspaper reports as testified to here by Mr. Canlas, the open quotation marks, it states, Sereno endured a harsh tongue-lashing from Justice Teresita Leonardo De Castro, the original ponente of the tampered TRO.
That is House Majority Leader Rodolfo Fariñas right there reading a portion of the impeachment complaint versus the Chief Justice Maria Lourdes Sereno. They are tackling the alleged falsification of a draft TRO that the Chief Justice did, which was drafted by Justice Teresita De Castro regarding a case of having to do with the Senior Citizens Party list. Now, Associate Justice Teresita Leonardo De Castro is one of the witnesses today alongside Court Administrator Maidas Marquez. They are, of course, giving testimony on several issues which had to do with, of course, allegations being brought by Attorney Larry Gadon in the impeachment complaint. Now, we will be back after a short break. Keep it here on CNN Philippines.
the factions of the Coalition of Association of Senior Citizens in the Philippines. So these two cases filed by the two different factions were consolidated and were raffled to me. So what I did right away was to study the case. This was in May 2013, just after the election. And the Senior Citizens Party was allowed to run in the election. So when it garnered enough number of votes, the Senior Citizen Party list was disqualified by COMELEC. So we thought that it would be unfair for the party list, Senior Citizen Party list, to be disqualified at that point where it has already garnered enough number of votes to be assured of seats in Congress. Now I prepared a synopsis explaining the case to the Chief Justice because we were in recess at that time, and I prepared a draft TRO where I explicitly recommended the issuance of a TRO against the COMELEC to refrain it from implementing the assailed COMELEC resolution insofar as the Coalition of Associations of Senior Citizens in the Philippines was concerned. I specifically mentioned this party list because this is the only party list involved in this case. So, considering that this matter was urgent, I did my best to complete all the recommendation and the draft and submitted this to the office of the chief. It was received early in the morning at around first hour in the morning. So I've been waiting in my office for her to arrive so that this TRO can be issued. But and in the meantime, at the time that I submitted the draft TRO, there were only 14 party list organizations which were proclaimed by COMELEC. But as the day went by, at the time that in the afternoon, already 53 party list organizations were proclaimed. So there was a danger that the senior party list organization may lose their slot in Congress. So finally, sometime in the afternoon, I think it was when the Chief Justice arrived, and I learned later on she did not call up my office, although I kept on asking the staff of the Chief Justice, was she able already to act on my recommendation, but I did not get any positive response until I received a TRO which did not refer to the COMELEC resolution which was in question. Because when we issue the TRO, we make sure to read very well the prayer. And the prayer would identify what is to be restrained. So in that petition of the senior citizen party list, it was very specific. It pertains to their disqualification pursuant to a COMELEC resolution. So the draft that I submitted mentioned the COMELEC resolution, and I mentioned that it is specifically about the senior party list only. Now, when later on, the TRO was issued by the Office of the Chief Justice, and I found out...
Meaning the Chief Justice?
Issued the TRO.
Yeah, the Chief Justice issued it, not the office. The Chief Justice po nag-issue ng TRO.
If we are in recess,
yes, ma'am.
It is the Chief Justice,
yes,
but usually it is upon the recommendation of the member in charge.
I'm just trying to clarify because you said the Office of the Chief Justice.
Sorry.
The Chief Justice.
Yes, I'm very sorry for that, Your
Thank you, ma'am.
So it was the Chief Justice who issued the TRO. And the tenor of the TRO is that the COMELEC is stopped from proclaiming all remaining party list organizations. So, parang to whom it may concern yung kanyang TRO. And so I was taken aback because I am being attributed to have recommended that because the TRO says upon recommendation of the member in charge, and I was the member in charge. So I wrote her a letter that you altered my recommendation. Why did you do that? She didn't even call me up to discuss
Ma'am,
this.
You refer to a letter. Do you have a copy of the letter, ma'am?
Ano, it was after na po na na-issue niya yun.
Yes, ma'am. You have a copy of the letter you sent to the Chief Justice?
Yes, Your Honor. I have
Maybe
here a copy
be
of the
given a
letter.
copy, ma'am?
So I was explaining that the TRO should only be directed against the senior citizen party list.
Which is the party in
Which
the
is the
case.
party to the
Impleaded
case.
party. Yes, ma'am.
Yes, impleaded party.
Yes,
and
ma'am.
it is very basic that you cannot include anyone who is not involved in a case.
Because it
in
will
a
violate
TRO,
their right to
because-
due process.
Yes, so I mentioned that, Your Honor, that will violate the right of the other party list to due process of law. And it will also violate the rights of their constituencies. They will be deprived of representation in Congress while a case is pending in connection with another party list organization. So,
Because this case include the squabble between the senior citizens only, hindi po ba? Nag-aaway
opo,
yung
yes.
grupo ni isang grupo, si Datol at saka si Artisa. Yes, ma'am.
Dalawa ho yung
Alam po
faction.
namin yan dahil mga colleagues po namin. Yes, ma'am.
Oh, dalawang factions. So sabi ko, why did you stop every party list which was not yet proclaimed at that time? Because she came to the office very late. There were very few slots available. And besides, I mentioned, you cannot deprive the COMELEC of its constitutional duty to enforce our election laws and to proclaim winning candidates or winning party list organization. So I wrote this letter to her.
Letter, from my quick perusal of it, it says, it is my view, the last sentence, that irreparable injury will be caused to the petitioner if its disqualification as a party list association and a ground concerning its nominees is not enjoined pending resolution. So what happened po? Did she reply to your letter, ma'am?
She replied, she said, because there are other cases pending in court, and she
May we
thought
also have a copy of the reply, ma'am? If there
yes,
is-
yes,
if you
I have a copy.
Yes,
It was
ma'am.
dated
Sige po.
May 30.
Yeah.
Now, but nevertheless, even if there are other cases pending in court, you should issue the TRO in those other cases, not do it in one case which do not involve them. So, I'd like to give you our exchange of communication in the.
Yes, ma'am.
So finally, when the matter was taken up in the court en banc, because the procedure is that when the court is in recess, the actions taken during the period of recess will be submitted to the court for ratification or confirmation. Now, many things transpired in the meantime, and there were really other cases involving disqualification in that election. So in some case, in I think 3 cases, the parties were only required to comment. No TRO was issued. Now in 2 cases, there were status quo ante order issued by the court. And in this senior citizens party list, the TRO issued by the Chief Justice was amended. I also gave my conformity to the issuance instead of a status quo or ante order because many things had transpired in the meantime that the court en banc was able to convene to act on this.
So, ma'am, just for the timeline to be clear, so you wrote to her, she responded, and you replied again, or you replied. Kasi so you said
yes.
a series of communications.
Yes, I issued a reflection, but I'm not so sure if I'm allowed to do that because the reflection was submitted for the deliberation of the court en banc.
As far as we are concerned, you are allowed, ma'am. In fact, we are asking you.
So I just explained. I just explained the. It has nothing to do with the. Well, I did not. I just explained that the TRO issued by the Chief Justice is contrary to my recommendation, and that.
Yes, ma'am. So what happened, ma'am? What was the decision of the en banc?
The en banc, since the en banc was able to meet on June 5 only, this happened in May 29, and from May 29 to June 4, nothing was done because the court was in recess. So the matter was acted upon on June 5. And on June 5, because of the supervening events, the court decided to issue a status quo ante order. I also recommended that in my reflection, and exclusively to the senior citizen party list.
So when you say status quo ante order, in effect, the TRO issued by the Chief Justice was rescinded.
Yes, no. Well, there's slight different. Yes, it was rescinded in the sense that it did not cover anymore all party lists.
Precisely, because it's status quo ante order is the last
Yes.
peaceable relationship between the parties before the controversy came into
And
picture.
specifically referring only to the senior citizen party list, because the TRO issued by the Chief Justice covered all of those party list organizations which were not yet proclaimed.
Do I get the impression, ma'am, that the en banc upheld your position?
Yes, Your Honor, because the en banc did not include other parties
Thank you, ma'am.
in the TRO. And what I did not like about the TRO is that I was alluded to as the one who recommended the
Which is inaccurate, of course, because what you recommended was only to apply to the
senior party list.
parties squabbling.
Yes, not to all
Yes, ma'am.
those not yet declared.
Totoo ba itong tanglasing na pinagalitan nyo, ma'am?
Exaggerated naman po.
Ayun. Alam niyo naman po, ang news,
Siyempre po.
ang news kasi bumibenta pag medyo ina-exaggerate ng konti. So,
Na-exaggerate
pero
lang po. Pero parang
you politely called the attention of the Chief
Oo,
Justice.
Kasi when I deal with her, pagka ho sa deliberation, formal deliberation, I say, I give whatever is on my mind to elucidate or to explain my position. Siyempre ho, minsan, ano tayo,
Nakikita ko ang passion niyo, ma'am. So, baka passionate lang.
But after that ho, after the en banc session, we eat together. Hindi ho kami nag-aaway.
At least this time, she replied to you, ma'am, unlike the Arcao na hindi ho kayo sinagot.
I just want to read to you a provision of the
Please, ma'am.
rule. The member in charge, that was me in that case, to whom a case is ruffled, whether such case is to be taken up by the court en banc or by a division, shall oversee its progress and disposition. So ako ho, as a member in charge, should have been consulted by the chief. And we could have threshed out our differences if only she talked with me instead of...
Because that is in fact the essence of ruffling the case to a particular
Member in charge.
justice, di
Yes,
po ba?
yes,
And it's not centralized with anyone.
Opo. Not
Opo.
anyone can act on a case or give any recommendation unless it is ruffled to you.
Do you have anything to add regarding this
Wala na po. That's
matter?
all, Your Honor.
Thank you, ma'am. Thank you.
Just one point, Madam Justice, and that rule applies whether the court is in session or in recess.
If the court is in session, we take it up during the session. And then on the basis of the issuance of the TRO is the decision of the court already. So it can be issued by the clerk of court citing the resolution of the court en banc or the division on a particular hearing date.
And when the court is not in session or is in recess, since the matter has already been given to you as a ponente, then yes, sir. Then it is imperative that there must be coordination between the Chief Justice and the ponente.
Opo, ang tawag po namin before the case is decided po, member in charge.
A member in charge.
Opo.
Thank you for that.
Mr. Chair, one last question in relation to that one. With the permission of the chair, Ma'am, Your Honor, we have heard your explanation, but I would just like to ask you, what is your reaction on this one? Because the Chief Justice filed her verified answer, and in relation to that allegation of yours, which you testified to right now, her answer to this one is, if I may quote, under page... In fact, this is allegation number 60 of the verified answer of the Chief Justice, paragraph B. On page 32. 32 ba ito? Walang page kasi. Yeah, 32. And it was said here, Your Honor, that since Justice De Castro was merely recommending a course of action to the Chief Justice, and further considering that the proposed temporary restraining order was merely a draft, the Chief Justice can wholly accept, modify, or even reject Justice De Castro's recommendation. The Chief Justice could not be accused of falsifying anything. In the exercise of her own discretion and authority to issue TROs, when the court is in recess, the Chief Justice elected is to issue a temporary restraining order under terms she considered just and proper. How would you react on this one, on the verified answer filed by the Chief Justice?
I disagree because I am the member in charge, and as I mentioned, under our rules, the member in charge oversees the progress and disposition of cases assigned to the member in charge. So the Chief Justice only issues the TRO, but she has no authority to act on the case on her own because
It must be consulted with you.
The case was not truffled to her. I am the member in charge, so I should be the one who should be consulted
And words of it, you were alluded
to be the source of what she did, and it was grossly unprocedural.
grossly unprocedural.
Because she included third parties who are not involved in the case. Because there was a blanket TRO issued against the COMELEC to stop it from proclaiming.
You are still watching CNN Philippines' continued coverage of the fourth hearing into the impeachment complaint filed against Chief Justice Maria Lourdes Sereno. You just saw an exchange between the Honorable Doy Liachon as well as questioning, of course, one of their witnesses today, Associate Justice of the Supreme Court, Teresita Leonardo de Castro. She is testifying today on two particular allegations or charges in the impeachment complaint, namely the falsification of a TRO drafted by De Castro in the case of a senior citizens party list, as well as culpable violation of the Constitution. We'll be back after a short break.
844-2245 was not revoked by the Supreme Court in bank. Would you agree with this one?
I will not agree with that because the status quo ante order referred only to the senior citizens party.
So, insofar as you are concerned, the answer, as I told you, and exactly reflected in the answer of the Chief Justice, is wrong based on the record of the Supreme Court.
I'd say that I cannot agree to that conclusion that she.
Thank you, Your Honor. Thank you, Mr. Chair.
Okay, we now recognize Congressman Bong Bilao.
Thank you very much, Mr. Chairman. Magandang hapon po, Justice Marquez and Justice De Castro. Salamat po sa kapaunlak sa aming komite na dumalo po sa hearing na ito. Mr. Chairman, before I ask the good Justice with respect to that matter on the senior citizen party list matter, can I just ask one question, Justice Marquez, because I think he's in the best position to answer a query on the matter of the ARCAO. Thank you, Mr. Chairman. Yung pong so far yung discussion na pinapalabas ng mga line of questioning so far on the violation of the principle of collegiality. Now, I personally believe that with what I've heard and the documents being alluded to by the good justice, there is already at least cumulative evidence on the fact of the violation or non-violation of the principle of collegiality as enshrined by Article 8, Section 1 of the Constitution. So far po, yun po ang trend ng questioning. Now, I would like to revert to another equally important matter, which is on the matter of the existence of the legal basis of the creation of the JDO. But before I answer, I ask the specific question, Mr. Chairman, let me just explain that yung pong the legal basis is that it appears that yung pong OCA, Office of the Court of Administrator, was created by virtue of PD 808. Di po ba? So, it was by virtue of a legislative grant of power, which under the time of President Marcos, he was exercising judicial power at the time. That is why it was by virtue of a judicial power that it was enacted, it was made. Now, ang tinitingnan ko po yung powers ng Supreme Court under the Constitution. I'm thinking that under Section 5, Article 8 of the Constitution, it specifically enumerates therein the powers of the Supreme Court. And to my mind, wala pong nakalagay doon na basihan among the specific powers enumerated under Section 5 of Rule 8, Article 8, Section 5, kung ano po yung basihan na source of power na dinelegate sa Supreme Court. If ever that would be Section 5, plausibly could make an argument is that the Supreme Court can promulgate rules of procedure in pleadings, practice, procedure in all courts. But of course, the ARCAO and the JDO is not a court. So obviously, this would not apply.
Your
so
Honor,
ang ibig ko pong sabihin...
Your Honor, may I intervene? We are already through with the ARCAO and the JDO problem. Please focus on the issue of TRO in relation to the senior citizens complaint.
Thank you, Mr. Vice Chairman. I'd just like to make this one specific question because I'm just saying the premise.
That's why, as alleged in paragraph 4.2 of the verified complaint.
Yes, Mr. Vice Chairman. Ang ibig ko pong sabihin, because of this, kailangan nating hanapin, it appears that we have to look at the residual power of Congress because Congress has plenary powers to legislate on almost anything, even if it's not given to a specific branch of government. Since wala po dun sa powers of the Supreme Court, then it must be legislative, just as in the same manner that we have PD 828. So, ang tinatanong ko po...
Your Honor, we are already through with ARCAO. We are already through with undue delegation, if at all, of legislative authority to create an office. We are only limited now to the TRO as alleged in the verified complaint 4.2 and
just one paragraph, Mr. Chairman, Mr. Vice Chairman. Ito po kasi, and the question ho is that under PD 828, can you give me a specific provision there na mag-justify for the creation of JDO? Kasi ang point ko po is that there is no basis. I'm looking for the legal basis for the creation of
Mr. Chair.
of JDO.
Mr. Chairman.
If any.
yes, Congressman.
With the
Deputy
indulgence
Speaker
of my
Garcia.
esteemed colleague, we are trying to follow a particular order here. And in fact, the JDO ARCAO issue had been extensively discussed already for several hours. And we need to move on because we do not wish to waste the precious time of our Justice, Associate Justice De Castro, as well as Justice Marquez. And with indulgence of my colleague, please let us now discuss the matter that is on hand, which should be the alleged
Deputy Speaker, it's just that we're just trying to dispense with this issue because I think
that has already been dispensed with precisely. So if we could possibly move on to the issue at hand, which is the issuance of a temporary restraining order as testified upon by our resource person. So we cannot go back to any matter that is no longer germane to what the resource person, the Honorable Associate Justice De Castro, has testified in relation to temporary restraining order in the case of consolidated cases of senior citizens. Yun na lang po.
Opo, Mr. Chair. Pasensya na po. But manifest ko na lang po. Kasi po ang ano dito, hindi lang naman the principle of collegiality, but the aspect of usurpation of powers because it appears that there is no basis for the creation of JDO because what I'm trying to point out is that kung hindi matrace to any provision of PDA 28 yung creation ng JDO, then what is the basis of that? So yun po sana ang gusto kong palabasin. If the good Deputy Court Administrator could trace to any provision.
Mr.
Anyway,
Chair.
I will proceed to another point po.
Please.
With respect to...
Salamat.
Okay. So with that at least clarified to me as a member of the Committee on Justice na wala pong basihan and we are here looking at the angle of usurpation of powers, I will now proceed. Please allow me, Mr. Chairman, to proceed to another point with respect to the other matter. I'm just simplifying it for my conscience to decide on this matter. May I address the question to the good justice po?
Oh, go ahead.
During the initial hearing of this case, yung pong, ako po yung nagtanong about the Senior Citizens Party List case. And the defense raised was that it was exercised by virtue of, it was made by virtue of an exercise of discretion ni Chief Justice. Ito po ba yung pag-issue ng TRO, blanket TRO, which is in contravention to the contents of the draft from the decision. Ngayon po, Madam Justice, ang release po kasi ni na Congressman Vilmonte is that yung daw pong pag-issue ng blanket TRO as it appeared in page, I think, 425 of the verified complaint, yung pong final TRO na lumabas, na blanket na po yung TRO na lumabas, it was in accordance accordingly with Section 6, Rule 7 of the Supreme Court, which accordingly grants the Chief Justice discretion to act unilaterally, even without the concurrence of the member in charge. Ang tanong ko po, Madam Justice, with your kind indulgence po, is that, ano po ba ang limits ng discretion na ito ng Chief Justice in the issuance of a TRO coming from a division? Ano po ba yung parameters ng discretion na yon, if any po?
Wala hong eksaktong ganyang language ho dito sa internal rules namin na may discretion. There's nothing here about discretion of the chief. You're citing rule. What rule are you citing? I have not come across...
Ito po yun, ito po, Madam Justice, yung in case of recess daw, pwede daw pong mag-issue ng TRO yung Chief Justice in accordance with the internal rules of the Supreme Court.
Ang provision ho dito, the Chief Justice or the Chair of the Division can take action on urgent matters. But it does not mention that the Chief Justice can disregard the recommendation of the member in charge who is under the same rule considered to be the one in charge of managing the case from filing to its disposition. And my point also is that not only did she not follow the recommendation, she stated in the TRO that what she issued was based on my recommendation, which is not true.
So, 2 points po ang ibig niyo pong sabihin, Madam Justice, na una po, it was false to cite the fact that the decision, the final TRO, was made with your concurrence.
Yes,
That's one.
Yes, Your Honor. She said she partially adopted it in the sense that she also issued a TRO. But it's not just a question of issuing the TRO. The terms and conditions of the TRO should be taken into account. So the fact that she included other parties who are not involved in the case is procedurally wrong. It is procedurally infirm. And I raised my objection to that because that will deny the right to due process of law of other parties. And also, it will impair the power of the COMELEC to proclaim candidates, winning candidates.
So, salamat po, Madam Justice. So, malinaw po yan na hindi po totoo na kayo po ay kinonsulta in the issuance of the final version of the TRO. Ngayon po, let us look at the contents of the TRO. Ang tanong ko po, under that aforecited provision of the internal rules of the Supreme Court na apparently grants discretion to the Chief Justice,
Wala ho, it doesn't say she's granted discretion.
it's the, on urgent matters lang po, tama po ba? Yung,
Let me see. She can act on the case, but it doesn't say that it is up to her discretion to do that, to overturn the recommendation of the member in charge to whom the case was raffled, because that will come in conflict with another provision of the rules saying that the member in charge should take responsibility for seeing to the disposition of the case from its filing to its final disposition.
in short, Madam Justice, forgive me if I did not get it right. Ang sinasabi niyo po, Madam Justice, is that there is no way by which the member in charge could be relegated to a position of non-knowledge with respect to the issuance of the final TRO coming from a division.
Yes, Your Honor, because the raffle of cases is the determining factor for one of us to be able to act authoritatively or legitimately on a particular case.
Madam Justice, ito po, pala point lang. Ano po? Ang sinasabi po yata ng rule is that in urgent cases. Ano naman po ang ibig sabihin ng urgent cases in relation to these situations?
Well, if there is no one, if the member in charge is not around, or if everyone is out of the office, then not only the Chief Justice but any one of us who is present can say issue a TRO. But when the member in charge is present, because the role of the case is given to the member in charge, so the member in charge is the one studying thoroughly the case.
Madam Justice, for the record po ba, were you around
Yes,
during
I was-
this time frame?
Yes, I was there. I was there in the prep. I saw to it that before I left the office the day before, I completed the synopsis of the case and the draft TRO so that it can be submitted to the office of the Chief Justice early in the morning. And I think it was submitted at 8:05 a.m.
Madam Justice, follow up ulit. Would it be material if it were a recess?
Yes, that we were on recess. We were in recess.
You were in a recess.
We were in recess, but I was there.
So you were saying po that even in case of a recess, there is an obligation on the part of whoever issuing the TRO to consult the member in charge.
In fact, the initiative should come from the member in charge because the rollo is turned over to the member in charge by the clerk of court. As soon as the raffle is done, because even if we are in recess, raffle is conducted. So we can be assigned to a particular case, and that was what happened. It was assigned, it was raffled to me. I was there, so I acted on the case and submitted my recommendation to the office of the chief so that she can issue the TRO.
Salamat po. Kasi kung i-compare po talaga natin yung draft, na which is attached as Annex, I think, 4.2-2 of the complaint, yung pong coverage ng terms, as you said a while ago po, with respect to the one appearing in page, I think, 452, yun po yung final version ng TRO, na iba po talaga yung coverage.
Opo.
So, now, ito po ang tanong ko, Madam Justice. I'm looking for a legal basis for that amplification. And if you stick to the provisions of the Constitution, it states there explicitly po nakalagay that all cases shall be decided by a division and you need 3 votes. And those 3 votes is defined specifically as composed of members who participated in the deliberations. And then, in case it is not reached, it is referred to the court en banc. And then another decision is made, again, with members participating in the deliberations. So, ang tanong ko po, Madam Justice, kindly indulge my curiosity, but I just like to be clarified. If there is a procedural violation of the Constitution, is that, ito po bang procedure, yung po bang unilateral na pag-amend o pag-expand ng content ng isang division output ay naayon po ba sa any procedural point, any provision in the Constitution? Meron po ba tayong masasite doon na any basis for that amplification, extrapolation?
This is just a matter falling within the ambit of the internal rules of the Supreme Court.
But you would...
Since it is the Supreme Court which has the power to promulgate rules on pleading practice and procedure, and this is part of the exercise of the power of the Supreme Court.
Thank you po.
Under the Constitution.
Madam Justice, ito po, again, just to satisfy my curiosity, kasi kayo po ang isa sa mga pinaka-senior justices of the land. I think you are narrating here narrative based on dun po sa nangyari sa term of Chief Justice po, Maria Lourdes Sereno. How about in the past po ba? Ano po ba yung practice with respect to issuance of TRO in similar cases? Ano po ba ang practice?
Wala naman hong pinagkakaiba.
Ganun pa rin po yung dapat na mangyari.
Wala naman hong kaibahan. I don't think there is any marked departure from what was practiced in the past.
So, ito pong nangyari sa senior citizens case po na pag-handle po ng TRO, this is really a deviance kasi kung pareho lang po ang treatment in previous terms of previous Chief Justices po. Tama po ba?
Tingin ko ho, wala naman hong pinagkaiba.
Opo. Salamat po. Thank you very much po, Madam Justice.
Welcome.
Point of information lang po, Your Honor, Madam Justice. Sinabi mo kasi kanina, and I agree with you, that Section 1, Rule 7, says every initiatory pleading already identified by a GR or UDK number shall be raffled among the members of the court. The member in charge to whom a case is raffled, whether such case is to be taken up with the court and bank or by the division, shall oversee its progress and disposition unless for valid reason, such as inhibition, the case has to be re-raffled, unloaded, or assigned to another member. So this is what I've been saying, guided by my experience when I was with the Court of Appeals. If a case is raffled to a particular justice, you become the captain of the ship of that particular case, or the master of the vessel. But we have also, in Section 6, Paragraph G, when the court in recess, and this is where the defense of the Chief Justice is anchored, when the court is in recess and the urgency of the case requires immediate action, the clerk of court or the division clerk of court shall personally transmit the rolio to the Chief Justice or the division chairperson for his or her action. The matter of the Chief Justice issuing a temporary restraining order is actually negated by two points you have raised. One, Section 1, the moment the case is raffled to you, then you are in charge of the case. And number two, this is already covered by Arroyo. The moment you are in recess, that rollo cannot just be taken away from you by the Chief Justice. And until such time that the rollo is taken away from you, the Chief Justice cannot issue a TRO. Is that correct?
And this provision that you cited refers to an instance where the case is not yet raffled to a member in charge. Wala pa po tong member in charge.
Very good. And this particular paragraph G will not apply to the problem we have at hand because this case was earlier raffled to you.
That is my position, Your Honor.
Thank you, Your Honor. The next is Vice Chair Waminal.
Thank you very much, Mr. Chair. Good afternoon, Madam Justice De Castro and Court Administrator Justice Maidas Marquez. Honestly, your enlightenment on the first charge has really improved my understanding on the case at hand and could serve as a best guide in casting my vote on that particular subject matter. So that in the second charge, Madam Justice, I would again appeal for your wisdom now, another enlightenment, so that we can be guided accordingly. Ma'am, on the issue of this TRO, as alleged in the complaint, what was submitted by you to the Chief Justice is a draft or recommendations. For our guidance, ma'am, because yung draft, sa layman's understanding, and even to most of the people, it is not yet final. A draft can be subject to revision, adoption in toto, or disapproval by the signing authority. So, in this particular draft that you have submitted to the Chief Justice, di ba pwede niyang i-revise or put it this way, is he under your roles mandated or obligated to sign or to affix her signature even if she doesn't like the draft or recommendation?
I think I would explain this in this way. In the Supreme Court, the member in charge is always obligated to submit a recommended action for every case assigned to the member in charge. So it is not that kind of draft or recommendation in common usage. It is different in the case of the Supreme Court. When we submit a recommended action, that should carry weight because the case has been ruffled to the member in charge. But we guide the court in the sense that we are the first one to study it and to submit our recommendation. It does not mean that especially in the case of the TRO, it does not mean that the Chief Justice, to whom the case was not ruffled, can set aside the recommendation of the member in charge. We call it recommendation because that is the term we use. Every session.
You are watching, of course, Associate Justice of the Supreme Court, Teresita Leonardo de Castro, testifying before the House of Representatives as they go into the fourth day of the hearings into the impeachment complaint against the Chief Justice Maria Lourdes Sereno. Associate Justice de Castro is testifying on so far on two charges versus the Chief Justice, namely the falsification of a TRO drafted by de Castro in the case of a senior citizens party list, as well as on the willful or culpable violation of the Constitution. So right now they are still discussing the charge of falsification of a temporary restraining order drafted by de Castro in the case of the senior citizens party list, and de Castro is explaining to the House of Representatives, the members of the House of Representatives Justice Committee, that in the Supreme Court, under their rules, the member in charge decides on the case, and what the Chief Justice did was grossly unprocedural when she revised or changed the recommendation that de Castro submitted to her. But she says that this was just an internal issue. Now, earlier on, de Castro also testified on the culpable violation of the Constitution. She says this was, of course, having to do with the revival of the Regional Court Administration Office in Region 7, or the RCAO. And the allegation is that the Chief Justice is trying to give legal basis for what she issued in her administrative order, which would have established another permanent office, but she is not authorized to do so. Now, we will pause for a short break. Stay tuned to CNN Philippines. Good afternoon.
Recommendation of Justice Reyes involving the same issue.
She did not at all consult me before issuing the TRO. And besides, even if she mentioned that to me, I will tell her we cannot include third parties here because every case should have its own case number, its own rollo, and any action to be taken in a particular case should be done in that case unless there is a consolidation decided upon by the court. Hindi naman po consolidated yun dito sa senior citizen party list. Eh bakit po namin yun papakialaman dito? We don't even know the background, the factual circumstances surrounding that case, the legal issues involved in that case. So why are we going to do something which will affect a party which is not involved in the case of the senior party list? That is violation of their right to due process, Your Honor.
Okay. My last clarificatory question, ma'am. Was this TRO affirmed by the court in bank after when you had already your session?
The court and bank issued a status quo ante order pertaining to the senior citizen party list only. Now, in another case, they issue also an SQA, but it is not in this senior citizens party list case, but in another case, because they were not consolidated. So so what happened is that we did not anymore mention any other third party in the SQA issued in the senior citizens party list.
Okay, ma'am. Thank you very much, Mr. Chair. That's all.
Next is Honorable Rocamora.
Thank you, Mr. Chair. Madam Justice, listening to your answer to the questions of Representative Uminal, it would appear that you are saying that even during recess, the action of the Chief Justice is basically just ministerial to your draft and recommendation. Is that so?
Your Honor, that is my position.
It's ministerial.
That is my position, but I do not know if the chief has their own opinion about this.
Is there anything at all in the rule, I believe 7 or section 6, that says so, that it's ministerial, that she cannot modify a recommendation when she believes that it is not correct?
While there is no such provision, there is no provision also giving the Chief Justice authority to set aside the recommendation of the member in charge to which the case is ruffled.
The rule specifically says that she is the one who will issue the TRO.
Yes, when I believe that is so, that she really has the authority to issue the TRO
Yes.
when the court is not in session. But she has to consult and follow the recommendation of the member in charge. It's not a question of there may be a possibility that she may be able to convince the member in charge to change her recommendation, but there must at least be consultation, because no one among us justices can act on a case unless the case is ruffled to that justice by means through the regularly conducted raffle.
So in short, even if she believes that the draft or recommendation is not correct, she has no choice except to sign her, put her name in it, and to put it another way, but just being a rubber stamp.
But that is not what I'm saying, Your Honor. What I'm saying is that, well, if she has her own idea or her own assessment of how to issue, as to the scope of the TRO, she should have at least consulted the member in charge. In that case, she should have consulted me before issuing a TRO, because the member in charge is the one who thoroughly studies the case.
So if she has the authority to modify it under the rules, her failure is simply in not consulting you.
Well, not only that, my objection is not only the fact that she did not consult me, but the fact that what she issued is procedurally infirm. If only she consulted me, I could have explained to her that you cannot include other parties in this TRO.
procedurally infirm. Could you say that this is but an error in judgment?
The thing is, she wrote in the TRO that it was upon my written recommendation. So why did she put there that the TRO that she issued was upon my written recommendation? That is not true. So, what I'm saying is that if she wanted to change or if she changed my recommendation, then she should have issued it on her own authority without reference to any recommendation coming from the member in charge. Why did she attribute to me what she did?
Is it not possible
I cannot defend and support what she did because it was not really my recommendation.
Madam Justice, is it not possible that she agreed with you on certain aspects of your recommendation?
Agreed only
including
as to
the issuance of TRO?
She agreed only insofar as we should issue TRO.
Ah, yes. So in effect, she is correct in saying that she complied with your recommendation to issue a TRO.
She agreed to issue TRO, but she wanted to include other parties.
I'm just limiting it to that question because you said that she alluded to your recommendation as part of the basis of her issuance of the TRO. So I was asking, it is entirely possible that she agreed with you on certain aspects of your recommendation, specifically that a TRO should be issued. Yes?
There is a big difference between the TRO that she issued and the TRO that I recommended. Because the TRO that I recommended is expressly mentioned the COMELEC resolution in question and the party who should be benefited by the TRO. So, how can I say that she adopted my recommendation when there are substantial differences between the TRO that she issued and my recommendation? Well, I would not have raised so much issues about this if she just did it without referring to any recommendation coming from me, because I will just reiterate at the en banc session my position. But the point is, why did she say there and put there in writing that this TRO is issued upon recommendation of the member in charge? And I do not want to be known to have issued such a recommendation which will cover other parties who are not involved in the case. That is not done.
Okay, thank you. Thank you, Madam Justice.
Now, on the before that, point of information. Rule 13, Section 3 of the internal rules provides the following. Section 3, actions and decisions how reached. A, initial action on the petition or complaint. B, action on incidents such as a temporary restraining order. C, decision or resolution. Now, B says, the member in charge shall recommend to the court the action to be taken on any incident during the pendency of the case. It does not say that the Chief Justice can interfere in this particular incident of TRO. Just as a guiding matter to our colleagues, are you done?
No, not yet.
Okay,
but let
you.
me comment on that. I would like to emphasize on the word recommend again. Recommend. Okay, may I proceed?
Go ahead. Thank you.
Madam Justice. Now, looking at the TRO itself, is there anything that says that it covers all party list? Is there anything there?
Yes, it mentions all party lists not yet proclaimed.
Where?
That is what is mentioned in the TRO. It says there, to cease and desist from further proclaiming winners from among the party list candidates.
Okay.
So, ano po yan? Kahit sino ho na party list, hindi
excuse
ko
me.
proclaim.
Since this is a specific case, could that party list, the winners only mean party list winners in the coalition?
Hindi po eh. Kasi,
It does not say it not.
it says from further proclaiming winners. Winners, plural ho to eh.
In connection with that term, plural winners, you made mention earlier that there is the possibility that some of the party list winners might not be able to get their seat because of the limited seat that is being offered under the law. That is correct.
That is correct. If they have their own case,
Yes.
the TRO must be issued in that particular
yes.
case, not here.
I agree. But by issuing an omnibus TRO for all party list, would it not help in preventing such injustice where a winning candidate can no longer take a seat in Congress?
Which party list? Which party list is injured?
All
There
party
is no-
list, the party list winners similarly situated.
But that party list organization must file its own petition before the Supreme Court. Because how can we act on that particular party list if we do not know the facts and the circumstances surrounding this party list organization?
I understand the procedural aspect of your objection, but I'm thinking of the basis, the reason why she could have issued that kind of a TRO. Because, you see, that's why I asked you earlier, whether, is this not just some kind of error in judgment? Because if just a simple error in judgment, we have to prove that it was malicious, or it was intended to benefit a certain parties with intention, malicious intention. But here, it seems that there is an intention to prevent an injustice itself.
She should be the one to explain that, Your Honor.
I was
I
thinking.
do not know. I cannot hazard a guess as to the state of mind of the Chief Justice when she issued the TRO.
Did it not come to your thinking that this could have been her reason?
I'm sorry. I think I have already answered the question, Your Honor.
Actually, she had answered this already.
Yes, where are we? I'm lost.
Okay. Okay.
Is there a question? Is there a pending question?
I believe I'm done here. Mr.
Thank you
Chair.
for that.
Thank you, Madam
So we
Justice.
now recognize.
Mr.
We
Chairman.
have a list here. Speaker, Deputy Speaker Gwen, then Congressman Ace, then Congressman Marcoleta and Congressman Batocabe, in that order, and Congressman Hernandez, Deputy Speaker Hernandez. I'm just reading in this list. So Hernandez and then Belmonte. You are now recognized, Deputy Speaker Gwen.
Thank you, Mr. Chair. let us go back again to the complaint, Mr. Chair, so we will have some direction. Well, the complaint is centered upon, according to Attorney Gadon, a culpable violation of the Constitution when she falsified the temporary restraining order of the Supreme Court in GR number 206844-45. And this GR number 206844-45 particularly refers to the case that was assigned to the member in charge, Your Honor, Justice De Castro. Am I correct, Justice De Castro?
Your Honor.
Now, in the Supreme Court, the processes are governed by internal rules.
Yes, Your Honor.
And in fact, I have here a copy of the internal rules of the Supreme Court, which was issued then on May 4, 2010,
Luma na yan eh.
during the incumbency of Chief Justice Renato S. Puno, of which, Your Honor, Justice De Castro was also a member of that court.
Yes, Your Honor, but there were so many other amendments to this up
Well,
to August.
I would merely wish to refer to Rule 7 as regards the raffle of cases.
Yes, Your Honor.
And please correct me if there were other amendments to the sections contained therein. As you had initially already pointed out, and as pointed out by the Vice Chair, may I refer your attention to Section 1, which states that in the raffle of cases, every initiatory pleading already identified by a GR or a UDK number shall be raffled among the members of the court. The member in charge to whom a case is raffled, whether such case is to be taken up by the court and bank or by a division, shall oversee its progress and disposition unless, for valid reason, such as inhibition, the case has to be re-raffled, unloaded, or assigned to another member. Is this still the rule?
Yes, Your Honor. Still
So
the same.
that in the case of the senior citizens versus COMELEC, particularly GR number 206844-45, in fact, this particular case was raffled to your good self, Justice De Castro.
Yes, Your Honor.
And what day was that? Would you remember?
Let me go over the record. Asan ba yung ano? Yung narration natin. Hindi ito eh, yung filing of the... Ito po, on May 14, 2013, the Datol petition was filed with the court. That was May
Mr.
14.
Chair, I cannot hear. I think, can we have a little silence? I can no longer hear, Mr. Chair. I'm,
May
also
I
senior
request
citizen.
everyone to maintain silence in this hall. Thank you.
Your Honor, the petition, one petition was filed on May 14, 2013.
And subsequently raffled to the member in charge, which in this case is your good self.
Yes, Your
Your
Honor.
Honor.
Yes, Your Honor.
And so the date of raffle was?
I cannot... We raffle cases every Monday. Monday afternoon. So I'm not sure when this was raffled to me.
Okay, if you cannot remember, well, when this was raffled to your sala, the rollo and all the documents pertinent to this case was then turned over to yourself.
Yes, Your Honor.
Now-
Both petitions, there were two petitions filed, one after the other. So the other one was filed on May 20, 2013.
So one was filed May 14th and the other one May 20.
Yes, Your Honor. Both petitions were raffled to me. Since they are related, they have the same cause of action, the same parties.
Now, since this was praying for the issuance of a temporary restraining order, then this should fall directly under Section 6 on the special raffle of cases. Please correct me if there have been amendments since then, but Section 6 of Rule 7 states, should an initiatory pleading pray for the issuance of a temporary restraining order or an urgent and extraordinary writ, such as the writ of habeas corpus or of amparo, and the case cannot be included in the regular raffle, the clerk of court shall immediately call the attention of the Chief Justice or, in the latter's absence, the most senior member of the court present. The Chief Justice. Is that correct?
Your Honor, I think there was no special raffle, but the cases were raffled to me through the regular raffle conducted by the court. This is done every Monday afternoon.
And at the time, the court was not yet in recess.
May, I think we are...
Kailan po
in
nag-start yung
decision
recess?
writing. Usually in May, we are in decision writing recess.
So the whole month of May,
Usually.
The court was in recess?
Yes, usually that is the case.
however,
So in-
there was a regular raffle instead of a special raffle conducted.
Yes, regular, because the special raffle is especially requested specifically by a party.
And
After
there was no such request.
When it is not a regular raffle day, say it's not a Monday, so a party can ask that, say if it is a Friday or Thursday, or any day other than Monday, a party can request a special raffle.
So that when these two petitions for a temporary restraining order were raffled to
me.
your
Yes.
good self,
Yes, Your Honor.
the clerk of court then transmitted to your office copies of the pleadings, and thereafter you started to study.
Yes, Your Honor.
So this should be after, because these are two, May 14th and May 20th.
Yes, Your Honor.
Kailan po lumabas ang inyong draft recommendation?
I prepared a letter dated May 27, 2013, but that letter was received by the office by the Chief Justice on May 28, the following day, at 8:05 a.m. That included already my synopsis. It's a summary of the case and the draft TRO.
The draft TRO pertaining to purely both cases.
Only, yes, in both cases, but pertaining only to the senior citizens party list.
Because both cases pertain to the senior citizens?
Yes, there were two factions.
Yes. In fact, these are GRs. I think we have the GR numbers. Dalawa ito.
Yes, Your Honor.
So on May 28, that morning, nandun na po yung recommendation ninyo.
Yes, Your Honor, on May 28 at 8:05 a.m.
Okay. So, first of all, hindi pala ito nag-special raffle of cases.
Hindi po.
In other words, this was regularly raffled and then turned over to you,
Yes,
Your
as
Honor.
member in charge, Your Honor.
And if there are two. Ang isa na file May 14th, yung isa May 20th, and already 8 days later, nandun na po yung recommendation ninyo.
Yes, Your Honor.
Okay. Now, kasi inuulit palagi, itong letter G under Section 6 states, when the court in recess and the urgency of the case requires immediate action, the clerk of court or the division clerk of court shall personally transmit the rolio to the Chief Justice or the division chairperson for his or her action. Case in point, yung dalawang final po na petitions, May 14th and May 29th, pinadala ba ito kaagad sa Chief Justice?
Hindi po, sa akin po.
Kasi nag-raffle nga.
Opo.
At kayo po ang naging member in charge.
Yes, yes, Your Honor.
Given the responsibility to come up
With my study.
with your recommendation.
Yes, yes, Your Honor.
And that therefore, with that recommendation, in accordance with the internal rules that are followed by the Supreme Court, that recommendation therefore should have been upheld by the Chief Justice.
Yes, Your Honor. Imagine I spent a lot of time studying the case. Then she comes in the afternoon and issues a TRO in a matter of hours.
Kasi po, naguguluhan lang ako. Siguro this should be better discerned. Letter G. When the court in recess and the urgency of the case requires immediate action, the clerk of court or the division clerk of court shall personally transmit the rolyo to the Chief Justice or the division chairperson for his or her action. Unang-una, hindi naman ito transmit kaagad to the Chief Justice.
Hindi po, kasi nga po meron ng member in charge. So this will apply if there is no member in charge yet.
Pangalawa, dalawang conditions Hindi lang when the court is in recess. Yung pangalawang condition is, and the urgency of the case requires immediate action.
Yes,
By the
Your
time that the Chief Justice issued her TRO, which substantially changed the essence or substance of your own TRO and yet ascribed such TRO to your recommendation, wala pa ba po kayong action noon? Hindi po ba sinabi po ninyo, sinubmit na niyo po May 28 pa yung recommendation nyo?
Early morning of 29 po. I prepared it the day before.
28 po. 28 po.
Early morning. Early morning.
Opo.
Yes.
8:05 po.
I prepared that on May 27. I saw to it and gave instructions that it should be given to the office of the Chief Justice first hour in the morning. So it was submitted at 8:05 a.m. to the Chief Justice. Now, this provision of letter
So
G
that, yes po.
is not applicable, Your Honor, because there is already a member in charge. The rolyo cannot be taken away from me and be given to the...
Be that as it may po, let us sabihin na natin in court or legal parlance, granted without a
You are still watching CNN Philippines' continued coverage of the House Justice Committee's hearing on the impeachment complaint against the Chief Justice Maria Lourdes Sereno. And right now you are seeing, of course, the testimony of Associate Justice Teresita Leonardo de Castro as she attempts to explain internal procedures of the Supreme Court to the members of the House panel right there. Now, Associate Justice De Castro is testifying today alongside Court Administrator Maidas Marquez to answer the House panel's questions on several of the complaints or the charges in the impeachment complaint. The first one being the charge of culpable violation of the Constitution. Now, the complaint alleges that the Chief Justice attempted to create a permanent office in Region 7, which the Chief or Associate Justice De Castro says the Chief Justice did not have the authority to do. Now, another charge that was in the impeachment complaint is this Chief Justice alleged falsification of a TRO drafted by De Castro in the case of a senior citizens party list versus the COMELEC. Now, De Castro says she did prepare a draft TRO where she explicitly recommended a TRO directing COMELEC to stop action disqualifying the group.
8:05 in the morning,
Yes, Your
yung recommendation nyo po.
Yes, Your Honor. I submitted that
In other
in
words,
the morning.
this TRO, in the first place, was issued in transgression or not following any of the rules that that do define or govern the rules of procedure, ito yun eh, the internal rules of the Supreme Court. And further po, since you only recommended as regards the petitions that you received, and this TRO now further expands it even, including other parties which were not certainly part of both petitions filed May 14th and May 20th, and yet ascribed to your recommendation. That such action was your recommendation to your good self. In other words, po, the rules, the internal rules of the Supreme Court were not in fact followed, to say the least.
Yes, Your Honor. That's how I see it, Your Honor.
And to more aptly describe it, were flagrantly disobeyed. Thank you. No further questions.
Thank you. We now recognize Congressman Ace Barbers.
Thank you. Thank you, Mr. Chairman. Hindi ko alam kung saan ako mag-uumpisa because I was awed by the questioning, the line of questioning by my colleague, Congresswoman Garcia. Mr. Chairman, good afternoon, Justice.
Good afternoon.
Ang tanong ko napaka-simple lang ho. It's very short. I'll try my best to make it really short. No? The intelligent points and opinions raised by my colleagues was answered intelligently by no less than the Justice. And I'd like to ask Madam Justice your personal opinion. If this particular transgression, as my colleague called it, constitute the culpable violation of the Constitution. I'd like to be educated on that. What is your honest opinion on this, Madam Justice?
Your Honor, I beg your indulgence. I've been declining to answer similar questions in the course of the proceedings.
I perfectly understand, Madam Justice. What about in the area of betrayal of public trust? Would you mind answering that?
I would also like to beg your indulgence, and
Just the
I
same,
would like to
Mr.
decline.
Chair, I also understand the position of the good justice, but just for my enlightenment, Madam Justice, and perhaps some of the members of this honorable committee, can you educate this representation of some decisions or jurisprudence of the Supreme Court with respect to the definition of culpable violation of the Constitution?
Right now,
If it will take a long period of time, I would ask the chairman to just do it next time, and I will yield my time to the other members who wish to ask questions as well. Would it take a longer time, ma'am?
if you want specific cases, then I need time to go over the decided cases of the court.
Thank you for that. Please submit a memorandum of authorities, Madam Justice, on this, so that this will also guide us in resolving.
Mr. Chair, because the reason why I ask that is because for us to be educated, it will come to a point where the honorable members of the committee, including the members of this Congress, when in plenary, would decide on this particular case. So, para lang ho for our own education and enlightenment. But if it will take a long period of time, I would accept the request of the good justice to just defer and maybe just comply with the request of the chair to submit to the committee yes.
In fact, the complaint itself of Attorney Gadon contains that, but I do not want to give him the time anymore so I will read it into the records. Culpable violation of the Constitution refers to an act that is committed through a deliberate and wrongful breach of the Constitution, and he cites constitutionalist Father Joaquin G. Bernas, 1987 Constitution of the Republic of the Philippines, a commentary, 1112, page 1112, series of 2 NP03. So this should guide us, but nonetheless, there was a request, and please comply with the request to submit some kind of a memorandum of authorities on the matter, Madam Justice. Are
Thank you,
done?
Mr. Chair. Yes, I don't want to belabor my point anymore, and I'm sure there are other members who wish to ask intelligent questions. I defer to and yield to their line of questioning, Mr. Chair. Thank you.
Thank you. We now recognize Congressman Marcoleta.
Salamat po, Mr. Chair. Madam Justice, good afternoon po. And please bear with us. And we beg your indulgence. So much has been asked of you in relation to this TRO issue, where the Chief Justice made some statements that when the petition was filed, you were in recess, and your draft was merely recommendatory, and so she has all the right to issue the TRO, deviating substantially from what you have drafted and suggested to her office. How grave is this act of the Chief Justice? If you are asked to describe, if you are asked to describe whether it is minor infraction, whether it is a grave issue, Madam Justice, we're talking here of the internal rules, which by heart you're supposed to uphold. Not to mention that your collegiality might be compromised. So, you are now being asked to describe, if it is wrong, how wrong it is, in relation to the collegiality requirement and in the internal rules which you will all uphold in the Supreme Court.
Your Honor, I do not wish to preempt the committee from making that conclusion or that judgment.
Madam, we will not take it against you if you preempt us. I think the very reason why you were invited before us, you are a special person in relation to the charges now before us. You are in a position to advise us. We as ordinary mortals, even if some of us here are lawyers, we look upon you as our superior, you being a member of the highest tribunal of this country. So, I don't think it is a very hard question. We're only asking you to describe how wrong it is in relation to the requirement of collegiality, in relation to your own internal rules, which you yourself also invoke. And you also tell us, lawyers of inferior qualities probably, na lahat po ng inyong gagawin nasa tuntunin. If the Chief Justice of the Supreme Court is the one involved in a transgression, no matter how minor or major, how would you describe this?
It is a very difficult question for me to answer. As I said, I would not like to preempt Justice, the former Justice Congressman Veloso, I think, will be in a position to give his opinion on
My only reply, Your Honor, is that if this were committed by a plain mortal, an RTC judge, or a municipal trial court judge, he should have been dismissed a long time ago by the Supreme Court.
So, Madam Justice, prescinding from that statement made by our colleague, we're talking here of the Premier Justice of the Supreme Court, the Chief Justice of the Supreme Court, whose actions can be emulated by inferior mortals like we are. We're confronted with the issue that has a transcendental importance. You will not deny us the opportunity to be advised on this very important and probably a very crucial decision that this committee will make in the course of our proceedings.
Pardon me, Your Honor, we do not give advisory opinions.
Okay. Okay, because
especially on matters that may in the future be elevated
Opo.
to the court.
Kasi kanina po, dahil wala naman po ako rito, meron po kasi kaming ibang mga committees pa, ngayon lang po ako nakaupo rito. Somebody informed me that even in the earlier charge, yung pong nakaraan, meron po yatang arkaw, our majority leader already asked you tungkol po doon sa transgression of the constitutional duty of the Supreme Court and Bank, which you upheld, hindi po ba? And you were asked whether or not the Chief Justice, the respondent in this case, violated the Constitution. You denied also. That is the same answer.
The one that we discussed earlier today pertains to a memorandum that I have issued, and so I have to.
Yes, madam. And you were asked whether or not the Chief Justice committed a culpable violation, and you said that you cannot answer that because you would not like to preempt the decision of this committee. Is that not correct?
Honor.
Okay, so last two questions. I will read this, madam, and this is very familiar to you. This is Article 11, Section 1 of the Philippine Constitution. Public office is a public trust. Public officers and employees must at all times be accountable to the people, serve them with utmost responsibility, integrity, loyalty, and efficiency, act with patriotism and justice, and lead modest lives. In our discussion this afternoon, Madam Justice, in relation to the two subject matters of today's hearing, was this section of the Constitution violated?
Your Honor, it is really difficult for me to draw a conclusion from everything that is before us now, because we need to give the Chief Justice the opportunity to defend herself. So
I'm not asking you a conclusion, madam. Probably an opinion.
Yes, but that is the same, Your Honor. And
That's the same.
I do not want to. I do not want to give an opinion which may prejudice the Chief Justice.
Okay.
Without her being given the opportunity to defend herself.
Thank you, madam. Of course, we will not force you to answer under duress. Ito na po yung huli. Article 8, Section 6, Paragraph 3, Philippine Constitution. A member of the judiciary must be a person of proven competence, integrity, probity, and independence. In the discussion of the subject matter of today's hearing, and for which you played a major role in discussing some of those hard issues that we need to confront, in all honesty, Madam Justice, was this article that I read to you was violated by the respondent Chief Justice?
My role here is just to provide factual matters to the committee, and I would like to refrain from making any conclusion with respect to the facts that are elicited in the course of the proceedings. I'm very sorry, Your Honor. I beg your indulgence.
But madam, when the Chief Justice deviated from your internal rules that you have testified to, in several instances, was it part of her competence to do that?
Again, Your Honor, please allow me to
Your Honor?
decline answering your questions.
You know,
Salamat po.
Pasensya na po
Madam
kayo.
Chair, Mr. Chair, Okay na po.
Alam nyo, medyo humihirap na yung yung sitwasyon, pati yung mga tanong, baka nahihirapan na kayo, Madam Justice, sabihin nyo lang po because, of course, we had been here since 9:30 in the morning. I think you arrived earlier. And so we have already consumed, how much? About 7 hours of your time. I'm almost certain some of us also. Pero kami ho, handa pa rin ho kaming magpatuloy. But we would like to ask you kung ano po ang situation nyo po so that we can be guided accordingly as to whether we should still continue or not. Pero having said that, may tanong lang po ako sa inyo muna, no? Yung rolyo po, kanino po yung rolyo nitong kasong ito?
Nasa akin po. Pagka-raffle, binigay agad sa akin.
And this rolyo was never transmitted to the Chief Justice?
The rolios were transmitted to the chief by my office when I already submitted with my recommendation and synopsis. That is the procedure in the court.
Ganun. So, naidala rin sa kanya po. Kala ko kasi yung synopsis lang at saka yung draft ang napunta sa kanya.
The rolyo is transmitted to the chief together
Okay,
with
sige po. I just wanted to be clear on that. Anyway, just again on a point of information, we do have some, and this is in response to the query of the Honorable Barbers, definition of culpable violation of the Constitution, and this comes from Arguego, The Framing of the Philippine Constitution, Volume 2, page 590, Cinco on Philippine Political Law, page 334, and report of the Special Committee in the impeachment case against President Quirino, and if I may quote, culpable violation of the Constitution. The term clearly implies that not every violation of the Constitution constitutes an impeachable offense. In order to be so, the violation of the Constitution must be culpable violation. And this has been construed to mean that a violation must be willful and intentional. That is Arguego. It follows that violations of the Constitution committed unintentionally or involuntarily or in good faith or through an honest mistake in judgment are not grounds for impeachment under our Constitution. That is the report of the Special Committee on in impeachment cases against President Quirino. The term implies deliberate intent, perhaps even a certain degree of perversity, for it is not easy to imagine that individuals in the category of these officials would go so far as to defy knowingly what the Constitution commands. This is Bernas, the intent of the 1986 Constitutional Writers, 1985 edition, page 765. So yun po yung mga definitions that should guide the members. No? Kaya po, pakiusap ko lang po, let us try to elicit facts from our resource persons. Yung pong mga conclusions of law, yung opinions, whatever, is something that is addressed to each and every one of us. Tayo po ang magdi-decide nito. We will be guided by this jurisprudence and or definitions as has been applied in previous instances of impeachment. Ano? So, yun nga ho, babalik ko ho kayo sa inyo. Okay pa ho ba kayo, Madam Justice?
Kaya pa ho.
Kaya pa. Ngayon naman ho, tatanungin ko yung mga miyembro, kaya nyo pa ba? Sige, we suspend for 10 minutes. We allow the resource person, Madam Justice, to take her merienda. Pero baka si...
Mr. Chair,
tanong kayo kay...
no, it's an administrative matter.
Okay.
During the hearing where we invited the University of the Philippines representative, it was disclosed that the salin of the Chief Justice could not be found in the records of the institution from 2001 to 2006, except that of 2002. Although we had already issued a subpoena to the Ombudsman, and I learned lately that an applicant for a Chief Justice, one of the requirements of the judicial GBC is for the applicants to submit their salin for the past 10 years. So in that connection, Mr. Chair, I move to issue a subpoena to Sisticom to the GBC requiring for the submission or production of the salin submitted by the Chief Justice in connection with her application as Chief Justice, that requirement of salin for the past 10 years.
We can get this.
Of Chief Justice Sereno.
Okay. So ordered. Let a subpoena duces tecum be issued to the custodian of these records in the Judicial and Bar Council to produce these documents, SALN, covering the period 20